see Mr. Fabian yet. Let's see. Good morning, Mr. Hotchkiss.
Good morning, Your Honor.
I'm going to assume Rudy is the defendant.
Yes, I believe so, and I think he's represented by Mr. Navarre.
Oh, okay. I didn't see that, so oops. Can you get him in here? And do you know if your client is logged in?
I spoke with her about 10 or 15 minutes ago, and she was going to be logging in.
I see a Jenny. I'll try that.
That should be her.
Morning, Ken.
Morning, Phil. How you doing?
Good.
All right,
Morning,
looks
Your
like
Honor.
we have an audio connection with everyone. Counsel, state your appearance, please.
Good morning, Your Honor. Ken Hotchkiss appearing on behalf of Jennifer Rabb.
Good morning, Your Honor. Philip B. Navarre appearing on behalf of Rudolph Rabb IV, the defendant.
And Shannon, both parties are also present.
Thank you.
Mr. Hotchkiss, this is your motion. Go ahead.
Thank you, Your Honor. Your Honor, these parties were divorced in 2014. They have one minor child, Jaden, who is now 11 years of age. At the time the parties divorced, they had joint legal and joint physical custody, which was essentially a week on, a week off arrangement. That arrangement changed in 2016. My client had some personal struggles and actually had consulted with Mr. Rabb, and it was agreed that at that time it would be in the best interest of Jaden if he were to stay primarily with Mr. Rabb. Now, unfortunately, since that time, Mr. Rabb has made kind of a concerted effort to exclude my client from many of the significant issues that are afforded her via the legal custody arrangement. Specifically, right now, we're talking about the school issue. And I should indicate that for 2.5 to 3 months earlier this year, my client had Jaden in her custody. And then throughout the summer months, pursuant to her summer parenting schedule, and then there was an agreement where she actually had an extra week. So she's had substantial time with Jaden since COVID began. The initial reason that Mr. Rabb agreed to allow Jaden to stay with my client was because of the COVID concerns. As I understand it, he and we're not sure if it's his wife. I don't know that they're ever married. I think he purports to be married, and I think Jaden believes they're married, but my client doesn't necessarily believe that. But in any event, they work at the hospital and would be considered probably at a higher risk for contracting COVID and then passing it on. And it was their concern at that time that that might happen to Jaden, and that's why they allowed Jaden to stay with my client. So I would suggest to the court that they didn't have any concerns that would have that were sufficient enough to find alternate arrangements or sufficient enough to thwart her extra parenting time that she had this summer. Now, Jaden is currently under the guidance of an IEP. He struggles with school, and my client has reached out to Mr. Rabb in an attempt to discuss options that are offered to him at Northwest. And one of those options was whether or not it made more sense to have Jaden in school or at home on using virtual learning. And quite frankly, Mr. Rabb's answer to her, and I have a text message or email message here, and I'll paraphrase and omit the profanity, but it says essentially, I don't care what you think, if my decisions don't impact what happens with your parenting time on your weekend, you're not going to have any say. My client's primary concern was that she felt that Jaden would do better in class learning because of his special needs. And given that Mr. Rabb and his significant other work full time, and so Jaden is left really to his own schedule at 11 years old participating in this virtual learning. My client is not working. She doesn't work during the daytime. She is available to spend every day with Jaden and work towards his educational goals and so forth. Now, I saw in Mr. Rabb's answer that Jaden's doing extremely well in school, and while there's certainly some positives to report, the last IEP that I have indicates that in a lot of the categories, he's performing significantly below the level of the same grade peers. He needs support accommodations, specialized instructions, et cetera, to make progress in the general curriculum. My client wants to be involved in that process. She thinks that affording her more parenting time and what she is asking for is to go back to the original joint physical custody arrangement where she can keep a handle on his education and continue to participate in a manner that is in Jaden's best interest. She really can focus her whole attention on Jaden because she's not working. They have alleged that they had some concerns about my client's housing, and my client reports that her housing is, she lives in a nice neighborhood, it's clean, it's suitable, and certainly well-equipped to have Jaden there with her. She thinks that her exclusion essentially from Jaden's life is just another one of the controlling tendencies that Mr. Rabb has had throughout the entire course of her relationship with him. So, and I guess on a final note, the thing that originally brought Jaden to my client for a few months at the outset of the COVID pandemic seems to even be more of a higher risk now. I think that given the numbers and what I've seen locally as far as the COVID reports with healthcare workers and so forth, I think they're probably at an all-time high here in Jackson County. So I would think that risk would still be out there. She's got a number of emails and text messages that we could provide to the court that would show the court that he's not cooperated with her in any meaningful way so that she can continue to be involved in Jaden's life. She's now in a position to do so. We believe that there's a change in circumstances. This pandemic has brought on a change in circumstances, as has Mr. Rabb's refusal to allow her to participate in Jaden's life. So we would ask that the court consider modifying custody and or parenting time to allow her to parent Jaden, and we believe that's in Jaden's best interest. Thank you.
Mr. Navarre?
Your Honor, did you have a chance to go through our answer to the motion?
It wasn't in the file when I looked at files on Monday, so no, I have not.
Then I'm going to go through it in detail, Judge, if you would please bear with me. Your Honor, I filed that response on the 21st of October. So I'm at a loss why 3 weeks later it's not in the file. So if you please bear with me, Judge. We admit the first two paragraphs of their allegations contained in their complaint regarding their motion regarding custody. And in paragraph 3, Your Honor, they indicate that motion filed seeking additional parenting time and evidentiary hearing on this issue occurred on May 15, 2017, at which time plaintiff's request was denied. We admit that as true, Your Honor, but my client further states that he proposed that if his respective holidays through the handbook revised in April 2011 from the front of the court, Jackson County, the holiday fell on her scheduled weekend, he was amenable for her to have Jaden on that weekend. And the referee at that hearing indicated, and I quoted him, "The referee is puzzled to the extent why plaintiff would not agree to defendant's specific proposal as noted above, to be afforded her weekend parenting time when defendant's holiday parenting time occurs on her weekend. Frankly, plaintiff's response proceeds contrary to the intention she maintained in filing her motion. In that regard, the referee is persuaded that defendant's offer is being made in good faith, with plaintiff's response being an unjustified flat refusal. He offered her additional parenting time when it would have been his holiday. So, if it was his Labor Day, he offered her the entire weekend. If it was a holiday that fell on her weekend, he offered that holiday. And she just refused. She says, no, I'm not going to do that. So if she's seeking additional parenting time, why would she take that? And that's what was noted in the referee's findings and facts. In paragraph number 4, Judge, they say that the current schedule is every other weekend from 5 on Friday to 6 on Sunday, as well as 4 weeks of summer parenting time. Holiday, school break parenting time is set forth in the party's judgment of divorce. That's true. My client was granted sole physical custody in this court's order of June 16, 2016. And the minor child sees the alternate weekend parenting time schedule with his mother as something that he is comfortable with and perceives as normal. In paragraph 5, they say plaintiff agrees to this parenting time schedule, hoping it would be helpful to the minor child in school in developing a more consistent routine. We deny that for the reason that it's untrue. When the June 16, 2016 order entered granting him sole physical custody, my client, it was clearly supported by the best interest factors and commensurate with the best interests of Jaden. This is further evidenced by his consistent routine, which he's followed, supervised or unsupervised, self-starting to meet and exceed expectations and responsibilities regarding schoolwork and responsibilities at home. His discipline in beginning and finishing tasks independently, his pride and satisfaction of being able to complete tasks without assistance, his recent highest score in his language arts class on a weekly assignment, and his sharing this accomplishment with his father by calling him at work and saying, "I'm smart, Dad." His impressive work in on time. In paragraph 6, they say that on March 24, plaintiff had the minor child in her care. The parties agreed to be in the best interest of the child, the plaintiff to maintain that care, as defendant and his wife both work in the medical field and wanted to avoid any risks of COVID-19. We admit that that happened on a temporary arrangement, and it was made over the concerns for the health, safety, and well-being of Jaden. It was a difficult decision for defendant and his fiancée to make. Both are employed at Henry Ford Allegiance Health, defendant in maintenance, which requires him to be in all areas of the entire hospital. And his fiance's employment is in the emergency and safety department, which also requires her to be in all areas of the entire hospital. So given the novel nature of COVID-19 and the uncertainties that were connected therewith in March of this year, the defendant did not wish to expose his son, given his past asthma-related medical issues and the necessity for breathing treatments, as he was perceived to be at high risk. Plaintiff maintained the care from March 24, 2020 until June 7, at which time the parties returned to their regular parenting time schedule. We admit that that's true. Defendant, my client, has always maintained serious concern about plaintiff's housing, but he felt that it was the lesser of two risks. In addition, Judge, in violation of CDC executive orders and MDHHS mandates and guidelines, the plaintiff irresponsibly violated quarantine at her residence and took the party's son to a friend's house, which was really a slap in my client's face and totally defeated the purpose and sacrifice that he was making to keep his son safe. He is observed through photographs of his son and of no social distancing, swimming, playing cornhole with his friend Olivia. Shortly after this incident, Jaden returned home to defendant's residence, where he's resided with his son for the past several years. Paragraph 8, they allege that during these months, she was able to assist their son, who was on an IEP, with online schoolwork. We deny that for the reason it's untrue, Judge, because there were 5 or 6 weeks during the 2 months that she had him where school was postponed and closed. So schoolwork wasn't required during that time. And schoolwork didn't start until the last part of April with an app called Seesaw. This was the school district's attempt to keep some normalcy and the students engaged in their post-COVID-19 performance. Determined their prior COVID-19 performance was what determined their grades. So there was no grading for that period of time at the end of the last school year. They allege in paragraph 9 that she as a joint legal parent would like to have the minor child utilized in-school learning, as an IEP has helped to give him the extra learning assistance he needs. Online learning, especially in my client's home, is detrimental to his educational process. We neither admit nor deny what she would like as it goes to her state of mind. We further deny the allegations for the reason that they're untrue, that online learning in defendant's home is detrimental to his educational progression, because that's just not true, Judge. The online education is the safest possible way of learning at this moment in time, and the district continues to have positive test results among staff and students. Given his past medical respiratory conditions, in-person schooling exposes him to significantly greater risks. In further answer, Judge, his IEP has allowed the classes, online learning and remote learning, and the teachers that Jaden has to facilitate his way of learning. So they custom and tailor-made it for him to excel and get the help that he needs remotely. And that's what the purpose of the IEP is for. And he is excelling in and gaining confidence from his performance, and he can accomplish tasks which he has previously been told he could not achieve by his mother. She has a history of demoralizing him by repeatedly stating that he has a learning disability and needs help, which is clearly not in his best interest. They alleged that during her 4-week summer parenting time schedule.
Mr. Navarre.
Yes, Your Honor.
If he has an IEP, hasn't he been determined by the school to have a learning disability?
Oh, yes, he has. He has difficulty in math, and in another subject he has difficulty in. But he's complying with the IEP on a remote basis and receiving services that he needs to receive to excel and perform well. And my client's compliant with what the IEP is requiring, and he's very, very actively involved in his child's education. And he's, frankly, Judge, he's excelling. He's doing extremely well. And there are plenty of concerns that my client had during the summertime for the well-being, safety, and health of Jaden. And he had a regular and consistent contact with him. He made and received frequent phone calls and stayed in close communication with him. And the facts alleged do not suggest an ability to exercise equal parenting time. And we believe that no proper cause or material change in circumstance has been alleged that would warrant a change in physical custody of the child at this time. They indicate what she would want and what she likes, Judge, but there really is not a material change in circumstance. And the issue with COVID-19 is fluid and dynamic. And yeah, there's more cases, but they have established protocols to more effectively deal with it at the hospital, within the community, throughout the state, through the health department. And it's something that's fluid. And we're seeing a lot more cases in our area. But most of those cases are coming from the age group of 20 to 29. A lot of it is, young adults, college students. And there's been a lot of outbreaks at school, as to be expected. But then when you put into the mix the fact that he's considered high risk because of his past history and asthmatic conditions that he has, and he requires breathing treatments, it's a joint legal custodial decision. The parties can't agree. I guess Your Honor has to have an evidentiary hearing in that regard. But as it relates to a change in custody, physical custody, she's seeking to change where he lives, where he resides, where his home is. She's seeking to disrupt an established custodial environment that's been in place since the hearing 4.5 years ago, approximately. And Jaden perceives that as his home. That's where he has been. It's a good environment for him. And of course, my client and his fiance take all of the safety protocols that are required through the hospital. Their temperature is tested. They test frequently. And I certainly think that there hasn't been anything alleged that would rise to the level of proper cause or material change in circumstance, because my client made a voluntary decision because of COVID-19 on or about the 24th of March of this year to permit and allow their son to reside with his mother for a couple of months.
Your Honor, I need just a brief second to respond to something Mr. Navarre keeps saying.
Go ahead.
Mr. Navarre keeps talking about Jaden's issues with his respiratory problems and that he's high risk. My client retrieved a letter from Dr. Jones, who is Jaden's doctor. The letter reads as follows: Jaden Rab, DOB 22709, is my patient. Although he required breathing treatments as a toddler, he does not have asthma. He does not have respiratory complications and is not a high risk for COVID. If you have any questions, please feel free to call the office. So either it's a lack of understanding by Mr. Navarre's client, or he's attempting to use that as a basis to further his cause. The only other thing that I would indicate that the issue that resulted in the first change of custody, Mr. Navarre talks about findings of fact on the factors and so forth. Well, it was essentially it was an agreed upon order. I get that the court has to sign off on that, but it was basically because my client voluntarily relinquished her custody. Thank you.
Judge, briefly, I need to address one thing, if I may, and that is that it was my understanding that that was what was represented to me by my client regarding the asthma and the breathing treatments, and I may have misinterpreted that, and I have no reason to doubt the veracity of anything that Dr. Jones would say. So either it was a misunderstanding by me or a miscommunication to me by my client, and so I want to certainly correct that in my pleadings verbally now. And I certainly, again, have no reason to doubt the veracity of Dr. Jones, who I have a great deal of respect for, and he's well known in the medical community in Jackson.
All right. Certainly, COVID has brought a lot of changes in many areas of life. But here, the fact that there was some initial concern given the defendant's occupation and the location of his occupation and that of his fiance, that he took steps to be extra cautious at a time when we were all learning what was going on with this virus. The fact that he was proactive in taking steps to ensure his son's safety for a period of time, I don't find is a sufficient change of circumstance to justify revisiting custody. Now, granted, we're still under COVID, but a whole lot more is known about it. And I don't see that this child is at any greater risk in one home over the other. So I don't see that COVID under these circumstances provides a sufficient change in circumstance to justify the court revisiting the issue of custody. As to parenting time, I realize the standard isn't as high, but I really haven't heard anything to convince me today that anything is sufficiently different in the area of parenting time to justify me wading into this matter. So I'm going to deny the motion. Mr. Navarre, you prepare an order?
I believe it was the plaintiff's motion, Your Honor. We filed a response to it, so I think it would be incumbent upon the plaintiff to prepare it. But
I'll prepare an order, Your Honor.
Well, Mr. Navarre, I usually ask the attorney who prevailed on the motion to prepare the order.
I'll prepare it.
I expect you to prepare it.
I will, Your Honor. Thank you, Your Honor. Ken, I'll send it over to you.
Okay, thank you, Your Honor.
Thank you. Okay, Stinson. Well, it looks like we lost Ms. Payne. She was signed in earlier. She must have had to sign into a different hearing because she's disappeared. So I'll have to pass on that. She was here earlier.
Shall I call her or?
You can if you want, but I'm gonna call something else.
Do I have 15 minutes or no?
Probably, yeah. I won't do anything till you come back, so you're safe.
Okay, thank you.
And let's see if I've got everybody on Stimson. I'm sorry, Clark versus Bynum. I see Mr. Stimson here. I see Ms. Danke. And let's see, I see Aaron Clark. And I see Larry Bynum. So once we have everybody in and connected to audio, this is a matter of Clark versus Bynum. Mr. David Stimson's here for the plaintiff, Ms. Danke for the defendant, and both parties are also present, but looks like Mr. Bynum's having trouble with his audio connection. So as soon as I see he has a connection, we will move forward. All right, looks like everybody's connected. Let's see, Ms. Danke, I think this is your motion on behalf of Mr. Bynum? No, I'm sorry, this is your answer.
It is my motion was to quash the subpoena that was issued to the Department of Corrections.
Yes.
Then a motion has been filed by Mr. Stimson, and you have my answer to that motion. That's not set until December.
Right.
But I wanted to make sure you had that because he references that motion in his answer.
It was on the top of the stack of loose papers in the file, so go ahead with your motion to quash.
Thank you, Your Honor. Judge, I have to correct one thing. They completely revised the discovery rules in 2020. So I've referenced 2.302A4. That provision that I cite is now found under 2.301A4 because they rewrote that. Michigan court rules are very specific that after a post-judgment motion is filed pursuant to a domestic relations action, the parties may obtain discovery. A subpoena was signed on October 12th. The cover letter to the Department of Corrections was dated October 12th. On October 16th, the Department of Corrections gave my client a copy of the subpoena when they received it. We contacted Mr. Stimson's office, spoke to his paralegal, Brandy Klein, indicated at that point that there was nothing pending in this case. There was no ability to subpoena information, and pointed out that when Ms. Clark had a different attorney, we had had exactly this same issue where they had issued a subpoena to my client's employer at a time when nothing was pending. The court at that hearing threw out, because then they filed a motion and attached all the discovery to it, and the court threw out that motion at that point. I never heard from Mr. Stimson. I received a courtesy copy of the subpoena. That was dated October 16th, which was the same day I had called them. They mailed that courtesy copy out. Department of Corrections has confirmed that on October 26th, they filed they provided the requested discovery to Mr. Stimson's office. He then files a motion on October 27th. The court rule says very clearly you can seek discovery after commencement of an action. And in a post-judgment motion, you can obtain discovery after the post-judgment motion is filed. So not several weeks before, but after you file it. When the court looks at the motion that he filed after receiving the discovery, there is nothing with respect to child support in that motion. But he requested my client's pay stubs for all of 2020. He wanted all of my client's hours of employment because he's saying my client's unavailable for parenting time. But in his motion, he's not asking to change parenting time. He just wants parenting time enforced. Ironically, the motion that he relies on to allow for discovery also violates a court rule. The parties had participated in mediation pursuant to MCR 2.412 paren C. Any communications during mediation are confidential. And his motion quotes my client as making certain assertions with respect to the time he's going to spend with his daughter. First of all, absolutely violates the court rule with respect to confidentiality. Second of all, in mediation, the parties never met. We talked to Mr. Hotchkiss in his office, and then Mr. Hotchkiss went to his conference room and talked to Ms. Clark and Mr. Stimpson. So to suggest that my client ever made any of those representations, it is a violation of the court rule, but is also completely untrue. Judge, at this point, obviously the court can't quash the subpoena. It's already been complied with. Department of Corrections was very prompt with respect to their compliance. The information wasn't even due before they had already complied. So what we're asking, Judge, is that the court order everything provided by the Department of Corrections to be destroyed. If it was shared with the plaintiff, that it be retrieved from the plaintiff and destroyed. We're requesting attorney fees with respect to the need to file this motion, given the violation of the court rules. We'll address with respect to Mr. Stimpson's motion, the violation of the mediation rules in December when he has that motion set.
Ms. Danke, could you give me the citation for the court rule regarding post-judgment discovery?
Yes, Your Honor. It's MCR 2.301A4. And I would just remind the court, you want to make sure you're looking at 2020 information, because when I looked up the court rule to double check it, of course, it pulled up the computer pulled up the old 2.302A4, which is where it was originally set.
Well, although I rely on the computer for a lot of my legal authority, I still have an official set of 2020 court rules. And I'm sorry, give me the citation one more time.
2.301A4. Should be availability and timing of discovery.
It is.
Oh, good. Because I don't have my hard copy of the book yet, so I'm looking at the computer. And A4.
Thank you. Mr. Stimpson?
Yes, Your Honor, a couple different aspects and a little bit of background on why these came to light. Ms. Clark in particularly had tried to work this out outside of the court system, working directly with Mr. Bynum, as she has with minor child on many occasions. And when she was discovering that the minor child was not being cared for by Mr. Bynum, but by other persons, that he was in fact not exercising parenting time, and she asked him about it, the response that she received was essentially, none of your damn business. That's a quote from him to her. So in inquiring about it, not able to be using things such as hearsay evidence from a child, she has to then substantiate it. She can either file a motion without sufficient evidence to understand that factual basis alleged in the motion and then do discovery, or she can issue a third-party discovery subpoena, which she's allowed to under 2.305, to a third party to retrieve documentation that isn't confidential. He has a duty to disclose to the friendly court changes in his circumstances associated with his wage and hour information. And he's required to do that on a regular basis. In this particular case, Mr. Bynum has not done that and misrepresented what he has both to the front of the court previously, but also to Ms. Clark. As it relates to the mediation disclosures, I think we can talk about that at the hearing in December. But these disclosures aren't for only the mediation, but were made by Mr. Burnham to Ms. Clark on multiple occasions associated with how they're to parent the minor child. So these disclosures aren't covered under some secrecy or settlement discussions or any of the other aspects that are associated with it. They're disclosed and further waived by Mr. Bynum at other points in time by disclosures and admissions of his own. Specifically, if you do read the rule 2.301, which was incorrectly cited by Ms. Vinke in our original motion, it says that after a post-judgment is filed in a domestic relations action as defined by subchapter 3.2 of these rules, parties may obtain discovery. It doesn't say that's the only way you can do it. It doesn't preclude a third-party subpoena in other aspects. Discovery is allowable for third-party subpoenas in other aspects so long as that is within the scope of discoverable material. And the court has continuing jurisdiction over all domestic cases. So there's an ongoing case. This isn't finalized. This isn't a personal injury case where there isn't additional aspects. The court has continuing jurisdiction on domestic cases until the child reaches 18 and the terms of a judgment are completed. So we acted as if we had continuing jurisdiction, and so we issued a third-party subpoena under 2.305. And
so Mr. Stimson,
301.
Mr. Stimson, if all of that is true, why do we have 2.301A4? What's the point of it?
This would
If
be
discovery
also
is available all the time in a divorce action, post-judgment, why in the world does 2.301A4 exist?
when you don't have minor children with continuing jurisdiction. If I have a divorce without minors, when there's a spousal support obligation, the court doesn't have that continuing jurisdiction of monitoring the issues associated with the child. That's why I would read that.
I would read it as saying there is no post-judgment discovery period except in a domestic relations action, but only after a post-judgment motion is filed. I mean, I realize there's post-judgment discovery as to assets in any civil action, but not discovery of facts. I have trouble understanding what other meaning I can ascribe to 2.3014. The fact that I have continuing jurisdiction post-judgment in a divorce action simply allows me to continue to entertain motions dealing with the child custody issues.
But the parties, Your Honor, also have obligations to inform of change in circumstances associated with pay, things of that nature with the friend of the court. So
Judge,
I agree with that, but that still doesn't say you get to discover those things without filing a motion.
And my client has not changed his employment. He was out for a couple of months because of COVID, but he continues to be employed by the same employer.
He's substantially changed not only his hours of operation by working third shifts, he's also doubled his employment earnings. And what other means does she have to know that he's lying to the court, not disclosing, or than to find discovery or file a motion without standing or any basis? I mean, that's the struggle part, which is why I read that to allow for that provision. And if I've misinterpreted that, that is not by some, malicious error. I don't know what her previous attorneys did. I wasn't party to those cases.
And that's why I didn't file my motion until I had brought to Mr. Stimpson's office attention the fact that we had been before the court on this very issue previously with her previous attorney. If the court accepts Mr. Stimpson's logic, every 3 months, someone could subpoena an employer for their ex-husband or their ex-wife and say, I want to know, I want his paychecks and I want all of his work records. It's solely for the purpose of harassment. The friend of the court has an automatic, every 3 year, we're going to review. If you request it, we'll review child support, we'll update everything. To suggest that you can just do that on your own because you feel like it. And this is why Mr. Bynum does not speak to Ms. Clark except in writing, because she constantly claims that he has said things that he flat out hasn't said.
Well, and that's
He
the
claims that he told her she was unemployed when she knew he had COVID. He was in the hospital for a period of time and then off work, not unemployed, but not able to work because of COVID for an extended period of time.
So, Ms. Danke, have you found in any of your research where a court has actually addressed this court rule? There's some kind of a reported opinion?
No, Your Honor. I don't think this issue's been appealed because I think the language is very clear. You have to have a post-judgment motion to be able to pursue discovery. When the court looks at 3.2.301, availability and timing of discovery, every court rule after that, like 2.305 that Mr. Stimpson cited, comes after that and has to fall within the availability of discovery. And there's nothing within that court rule regarding availability and timing of discovery that would allow for all the other things that are permitted in 2.30, 2, 3, 4, 5, 6.
Well, I wasn't asking whether a court had ever interpreted that language. I was more concerned with, has a court ever, has a reported decision ever talked about sanctions when discovery is obtained in violation of this rule?
Oh, I did not research that, Judge. I can certainly do that and submit that to the court if the court wants.
I'm going to take a look at the issue. If you find something, you're welcome to submit it, either one of you. I'm going to have Peter do some quick research. Frankly, my inclination is to award sanctions. You can't just willy-nilly be sending out subpoenas if you don't have a pending case or a pending motion in a post-judgment in a divorce case. That's an abuse of the process. The subpoena power is a very intrusive power. And the court rules make specific exceptions when there's ongoing litigation so you can get at information regarding your case. But absent a pending action or a pending motion in a post-judgment motion in a divorce action, you shouldn't be able to use this intrusive power to dig into whatever information you want. So my sense is that sanctions are appropriate here, but I want to take a quick look first just to see if any court has addressed it before.
Yes, sir.
So if you want to submit,
I don't know that answer, Your Honor. I don't.
I'll give you a chance to look. I'm going to look myself, or Peter's going to look, and I'll just issue something in writing if I find that's appropriate. Thank you, Counsel.
Judge, what about our request to have those documents that were turned over by the Department of Corrections destroyed?
Well, the problem is he now has a post-judgment motion, and going through the exercise of destroying and then having to re-subpoena the same documents from the Department of Corrections is going to put the Department of Corrections to unnecessary duplication. So since there is a pending motion and a reasonable basis for why that information would bear upon that motion, I mean, the horse is already out of the barn. I believe sanctions are appropriate, but I don't want to punish the Department of Corrections for responding to the subpoena, which is effectively what I'd be doing.
Understood, Your Honor.
Thank you.
Thank you, Judge.
Your Honor, may I make a brief inquiry?
Yes.
In the last matter I had, I filed that on the 21st of October, my answer. Would it be appropriate from a protocol standpoint for me to send a copy to Peter, or what would Your Honor prefer?
Absolutely. I don't know what the issue is, but I keep getting files that don't have current stuff in them. I don't know why, but if you want to make sure I see it, absolutely. You may email a copy
I wanted to
to
follow
Peter.
protocol, Judge. I wanted to follow protocol, and so I will do that. This was the 2 consecutive motions, one last week and then this one this week. We haven't received a response, and they were, lengthy responses. So thank you for that edification. And thank you also for the edification on the prevailing party concept that you have, and I certainly agree with that, Judge. I have one more matter. We're waiting for Shelley Dungan. We'll be very brief.
All right, well, I am calling the matter of Clark versus Hinson. I see Mr. Fallahy and Mr. Whiting are here. I'm looking for, looks like Mr. Whiting, your client's with you?
Correct, Your Honor. And I believe Mr. Fallahy's client is in his office as well.
Correct, Your
Okay, then I don't have to look anymore. Okay, well, let me grab the file. Okay, and Mr. Whiting, this is your motion to expand parenting time.
That's correct, Your Honor. However, Mr. Fallahy and I have been talking with our clients this morning, and we have reached an agreement that we would like to place on the record, and then I will be preparing an order to reflect that for the file.
Okay, go ahead.
So the parties will expand parenting time to every Sunday from 9:30 a.m. to 8:30 p.m., continue to be supervised, and either party may renotice a hearing on to modify the parenting time. All other orders not in conflict with this order will continue. And we're going to see how the parties continue to progress with this current order.
Is that your agreement, Mr. Fallahy?
Judge, if I could just have one quick second with my client, I'm going to mute myself. I'll be right back.
Okay.
Yes, Judge, my client, for the record, is here with me in my office. We've had an opportunity to speak both on the phone and in person today. Just confirmed with him that he is in agreement with adding that Sunday parenting, Mr. White.
Very well. I'll look for the order.
Thank you very much, Your
Have a good
Honor.
day.
All right, you too.
Were you able to reach Ms. Payne?
I didn't try, I thought perhaps you would.
She's still not signed in. I'm gonna guess she's probably in another court hearing somewhere, but she was signed in earlier
Okay,
and she has disappeared. Okay, let's see. Good morning, Mr. White.
Morning.
I'm ready to hear Abby versus Abby, but I gotta let the parties in. As soon as we have audio connections, we will move forward. No, I've got the wrong person in here. This happens occasionally. When I click on one name, the delay between letting that name in and clicking on the next one results in it jumping to the next person. So there's Mr. Abbey. I thought his is the one that I clicked on. So it looks like we've got a connection with both parties. Shannon, Kelsey Abbey, and Cody Abbey are present.
Okay.
Mr. White, go ahead with your motion.
Thank you, Your Honor. I know the court's reviewed it. I've not received an answer of any kind. My client is simply entitled to and in need of assistance with daycare. It's a component of the Michigan Child Support Formula, and I would simply ask that you send this to the friend of the court so that they can recalculate that. It shouldn't take them a long time, and it can affect other aspects, as you know, from the formula. So it's not like we could just plug that number in. We just ask that you send it to the friend of the court, Your Honor. Thank you.
Mr. Abbey, did you have anything you wanted to say?
So I guess the only thing that I was looking for is to add the child care expenses in, but we previously already had an agreement for child support, and circumstances have not changed as far as financial needs go or our income. So I was looking to just add in that child care.
And I think that's all Mr. White is asking for.
That's correct, Your Honor. They'll just take his income and her income. Once they put the child support in, the program calculates the percentages.
Okay.
All right. Mr. White, you may submit that order, and we'll see that this gets sent over to the front of the court.
Great. Thank you very much, Your Honor.
Thank you. Have a good day.
You too.
All right. Thank you.
Your Honor, I did call Ms. Payne. I received no answer. I texted her, received no answer.
All right, well, I'll keep my eye on the waiting room and see when she shows up again. Good morning, Ms. Laux.
Morning.
Let's see, you're going to present proofs in support of a divorce judgment this morning?
That's correct.
All right. So Ms. Orozco is not signed in under her name. I've got a couple phone numbers here. Let me see who they are. Telephone number ending in 1243. What is your name?
Teresa Orozco.
Ah, good. I got the right one. Ms. Orozco, would you raise your right hand, please?
Yes.
You do swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your full name for the record.
Okay.
Ma'am, state your full name for the record.
Teresa Orozco.
Go ahead, Ms. Laux.
Ms. Orozco, at
Yes.
the time we filed the complaint for divorce, had you been a resident of Jackson County for at least 10 days in the state of Michigan for at least 180 days?
Yes.
In the complaint for divorce, you allege that there's been a breakdown of the marriage and there's no reasonable likelihood that the marriage can be preserved. Is that still a true statement today?
Yes.
How many children do you have with your husband?
3.
And what are the children's names and ages?
Christian Orozco, he's 17 years old. Osvaldo Orozco, 14 years old. And Lucero Orozco, 9 years old.
Are you currently pregnant?
No.
Have you had an opportunity to review that final judgment of divorce?
Yeah.
Okay. And were you in agreement with the terms in the judgment?
Yes.
Do you believe it provides a fair division of the property and debts of the parties?
Yeah.
Did you voluntarily sign the judgment?
Yes.
And was your husband also in agreement with the judgment?
Yes.
And did he also sign the judgment?
Mm-hmm.
I have no further questions, Your Honor.
I'm satisfied with the proofs. There's been a breakdown in the marriage relationship to the extent that the objects of matrimony have been destroyed. There remains no reasonable likelihood the marriage can be preserved. I have a consent judgment that's been approved by both parties and their attorneys. I have signed it, as well as the uniform child support order that is with it. And I am granting the judgment of divorce. Thank you.
Thank you.
Thank you.
Okay, next up, I've got a pretrial in the matter of Tanner versus Tanner. It's kind of a hassle for me to close these things out and go back into chambers. If you'd like to have a confidential conversation with me, we'll do that. But I'll leave that up to you, counsel.
I don't believe it's necessary.
Good morning, Shelley.
Morning.
Your Honor, I believe we've resolved matters. We had just a couple of issues and we were able to talk about that. Neither one of our clients are currently available right now, Judge, because of work issues out of state for Mr. Tanner and my client's situation today. So she's not available to appear remotely, and neither is he at this time. What we would like to do is we're going to get a consent judgment prepared, and then I will notice up a pro confesso hearing for us to take proofs, Your Honor.
So we currently have you on for a trial on December 10th. Can we just change that to a pro con?
I think the parties would like to be divorced before that, Judge.
All right, well, what I'll do is I'll change the trial to a status conference. And if you can get a pro con scheduled before then, you're more than welcome.
And Judge, what dates or what days of the week and times do you normally schedule those for my edification?
Thursday mornings, 9:30. If that doesn't work for your parties, just get with Dawn. We can squeeze you in other places too.
Thank you.
I'll contact Dawn. Thank you, Your Honor.
Thank you. Have a good day.
Have a good day, Your Honor.
Thank you.
You too.
Thank you, Shelley.
Thanks.
And let's see. Hutchinson, Whiting, Whitaker. Okay. Whitaker versus Whitaker. We are on the record. It's kind of a hassle to close this out and run back into chambers. If you need to speak with me confidentially, we can arrange for that, but
I don't believe that will be necessary, Your Honor. Mr. Hotchkiss and I have been speaking this morning, and the parties haven't really had an opportunity to fully sit down together, and we feel that mediation may be more appropriate in this matter. My client is in agreement with that, unless Mr. Hotchkiss has heard differently. I think we are going to head in that direction, and Mr. Hotchkiss and I are going to discuss which mediator we'd like to use.
so it sounds like you're gonna need a new trial date so that you can
Given
make
the
that
holiday
happen?
schedule and getting a mediator, probably, yes.
Mr. Hotchkiss, if that's acceptable to your client, if you could please submit a stipulation and order, we'll plug in some new dates for you.
Okay, I'll do that, Your Honor. Thank you very much.
Just when you send it in, indicate how much additional time you'd like.
Okay, will do. Thank you.
Okay, thank you.
Thank you, Your Honor. Have a good morning.
Thank you.
You likewise. She's still not signed in, Jan.
What do you want to do, Your Honor? I have a terrible time getting orders entered in this case. Tell me what to do.
I mean, you can wait. She was here, so I'm assuming she's tied up in another courtroom, which unfortunately happens. If you don't want to wait around, you can renotice.
I don't want to renotice. This case has been going on since 2018. We run into this all the time.
All right.
I'll wait, if that's okay with you.
Of course.
Her client isn't signed on either?
Doesn't look like it.
Okay.
Yours is. I've got a Galaxy, but usually I think he puts his name in.
You have a what?
If they don't put their name in, I get the name of the device.
Right.
So it's a Galaxy
Right.
device that's logged in.
Gotcha.
Good morning, Mr. Falahy. We're ready for Kebnick versus Kebnick. And as soon as we have an audio connection with Ms. Kebnick, we'll proceed.
Good morning, Judge. Can you hear me okay?
Yeah,
It's Mr.
There we
Fleming,
go.
by the way.
okay. Ms. Kebnick, would you raise your
Yes.
right hand, please? You do swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You can put your hand down now.
Hello.
State your full name for the record.
It's Diane Margaret Kebnick.
Go ahead, Mr. Fleming.
Thank you. Ms. Kebnick, with my assistance, we prepared a complaint for divorce, correct?
That's correct.
And all the allegations in that complaint at the time that you signed it and we filed it were true, correct?
Correct.
And are they still true today, all of those allegations?
Yes, correct.
Now, with my assistance, we prepared a judgment of divorce, correct?
That's correct.
And you had the opportunity to look it over and review it, read it, understand it, ask me questions about it, correct?
That's correct.
And this judgment of divorce is a consent judgment of divorce, meaning that you and the defendant, James Kebnick, decided upon these terms for your judgment of divorce, correct?
That's correct.
Okay. And you have affixed your signature to your copy of the judgment of divorce, correct?
I'm sorry, could you repeat that? I have what?
You affixed or signed the judgment of divorce.
Yes, yes.
And also, Mr. Kebnick, and you're familiar with his signature, also signed this judgment of divorce, correct?
Yes, he did. Yes,
So, and you're requesting that the court enter this judgment of divorce.
that's correct.
Thank you. Okay. Now I have to ask you, and I've asked you this before, but you are not now pregnant, correct?
No, it would be the miracle child.
Okay.
I'm
And
not
there-
Mother Mary.
Thank you. So there are no minor children of the divorce, correct? Of the
That's
marriage.
correct.
All right.
That's correct.
And have the bonds of matrimony been broken down to the extent that there remains no reasonable likelihood that the marriage can be preserved?
That's correct.
And you're also asking that the court enter a qualified domestic relations order at the same time, and hopefully those are right in front of the judge right now, correct?
That's correct.
Thank you. I have nothing further, Your Honor.
I'm satisfied, based upon the proofs, that there has been a breakdown in this marriage. To the extent the objects of matrimony have been destroyed, there remains no reasonable likelihood the marriage can be preserved. I have signed the consent judgment of divorce. I have inserted the date of the judgment of divorce in the qualified domestic relations order, and I've also dated and signed that. Ms. Kebnick, you are officially divorced.
May I ask a question? How will the
Yes, sir.
Carpenters Union get that signature from you, Judge? Do you send that? How do they receive that?
Mr. Fleming will take care of that.
Yes. Your Honor, may I come down there and pick up the file, take it down to the clerk's office and true up copies? And I guess I'll need a certified copy of the qualified domestic relations order.
Certainly. So you want us to hold the file here?
It'll be easier because sometimes it takes 2 weeks when it makes its way down to the clerk's office.
And do it. Okay, I'm sorry. Go ahead.
Just ask for Peter when you come for the file.
Okay, thank you.
Okay, then my question is, how soon will I get a copy of the divorce papers?
Okay, Diane, I will take care of it, all right?
Like ASAP?
I'll bet for you anything.
I hope so. Okay, so everything's all said and done, and I appreciate being able to take care of this through Zoom, because that would have been 80 miles for me to travel, and in this day and time, it's not good for anybody, so thank you.
We are happy to accommodate you, ma'am.
Thank you, Judge.
Have a good day.
Thank
All
you.
right, and you do the same. Okay, Jim, we'll talk here, okay?
Okay, goodbye.
Thank you very much. Bye-bye.
Thank you.
Bye-bye. You see, what do I do?
You can see leave in the.
Oh.
Your Honor, I did get a text back from Ms. Payne. She said she'll be a few minutes.
Right, I'll keep looking. Ma'am, on the Galaxy device, what is your name?
Can you hear me?
What's your name, ma'am? I can
Heather
now.
Maitland.
What's your name? Heather
Heather
Maitland? Oh, okay. You're scheduled today for a pretrial. What happens at a pretrial is I determine whether or not there's going to be a need for a trial. This is a divorce without minor children. Have you and Mr. Maitland already divided all of your personal property?
Well, when we got married, he was already incarcerated and he didn't have anything when we got married. So.
Do either of you own any real estate?
I'm buying a house on land contract.
You don't want him to have any interest in that house, I would assume?
No.
I notice his address is Newberry. Is he still incarcerated?
Yes.
We're gonna have to make arrangements for him to participate then. You're scheduled for trial on December 10th. What we will do is we'll communicate with the prison, ask them to make Mr. Maitland available. I don't expect it will take very long based upon what you've told me, but there really isn't anything I can do this morning. So you're scheduled on December 10th at 1:30. Just zoom back in at that time. We will make arrangements for having Mr. Maitland brought into the hearing by this Zoom technology. And we should be able to get you divorced on December 10th.
Okay.
Thank you. Have a good day.
You too.
Okay, well, I don't think I have anything else scheduled until 10. So Shannon, you can take